Hello and welcome everyone. I hope this message finds you fit and fine. In Lakshmikant series today, we are going to discuss special provisions for some states. First question which should come in your mind is why some states are having special provisions for them in our constitution. It means there must be some different challenges on ground in these states. Once you connect with those challenges, it would be cakewalk for you to understand why those provisions were made and what these provisions are saying. UPSC has asked questions from here. Question on Nagaland, question on Sikkim, directly from provision. Once you read the provision, question will be done. Okay, so let's start. So if you find any difficulty at any point of time and you feel I can be of help, then you can shoot me a message on my personal Instagram handle. Now, Article 371 to 371J, we are having 12 states here. One question can be, which of the following state is not part of this? Part 21 having special provisions. So just go through the names. Now some of you might be thinking, sir, do we need to cram the names? It would be easy for you if you just look at the map, look at the location of these states. You will find similarities and it will be fixated in your mind. Maharashtra, Gujarat, Nagaland, Assam, Manipur, Sikkim, Mizoram, Arunachal Pradesh, Telangana and Andhra Pradesh, then Goa and Karnataka. So it means if you do the clubbing, just look at the map, then it would be easy, right? Now, in original constitution, we were not having these provisions. Constitution did not make any special provision for these states. They have been incorporated by various subsequent amendments. So there can be a question on that, please remember it. Now provisions for Maharashtra and Gujarat. Now we are going to go state-wise. So what it's saying? Article 371, President is authorized to give power to whom? Governor. Okay. Maharashtra and Gujarat would have special responsibility. So these governors are going to have special responsibility. What is special responsibility? Just look at the development board. Development board. For the reasons, when we are talking about Maharashtra, so there are three kinds of development boards which they are talking about. Vidarbha, Maharashtra and rest of Maharashtra. Okay, so Vidarbha, Marathwada and rest of Maharashtra. Okay, there are three boards. Saurashtra, Kutch and rest of Gujarat. SK and then rest of Gujarat. So there are three boards. Making provisions regarding reports on the working of these boards to be placed every year before State Legislative Assembly. Okay, every year their report need to be presented before State Legislative Assembly. Why we are having these boards in first place? Equitable allocation of funds, and the focus is on developmental expenditure, means they should be equitable there, and along with this technical education need to be provided, vocational training need to be provided, employment opportunities need to be developed in these areas. So why we have these provisions? Because if you look at the areas, Vidarbha, Marathwada, we have seen that there is, you can say, disparity when it comes to level of development. That is why these areas needed some special focus. Okay. Now provisions for Nagaland. Just attempt this question now. I have not explained this to you. Just read this question so that you can relate the importance of that provision. Acts of Parliament related to the following matters, means we are talking about matters, would not apply to Nagaland until and unless the State Legislative Assembly so decides. Means Parliament has made the law, but it is not going to apply in Nagaland till that State Legislative Assembly approves that. So what are those matters? So matters like religious and social practice of Nagas, Naga customary law and procedures, administration of civil and criminal justice involving decisions according to Naga customary law, ownership and transfer of land and its resources. So which of the following matter? Answer is all. 1, 2, 3, 4. Okay. Now this thing is directly mentioned in Article 371A. Just take a look. Religious and social practice, Naga customary law and procedure, administration of civil and criminal justice involving decisions according to Naga customary law. It means you cannot say that if you are a Naga person in this area, then we are going to deal with you as per IPC only, Indian Penal Code only, right? If you do that, consider you are an officer in that area and you are thinking like that, then someone will actually sensitize you. Sir, please read Article 371A. How you have cleared UPSC if you have not done this? So you will say, sir, I have forgot it. Ownership and transfer of the land and its resources. Governor of Nagaland shall have special responsibility with respect to law and order. In the discharge of this responsibility, the governor, after consulting with Council of Ministers, exercises his individual jurisdiction and decisions in this regard. Now, there can be a question statement here. Can President actually take away the special power of governor with respect to law and order given in Nagaland? What do you think? It would be true or false? Some people would think, no. You are saying governors, and governor's role is important as per Article 371A. No, President can take it, because President is the one who actually gives these powers to governors in these special provisions. The special responsibility of the governor shall cease when President so directs. That is why I am saying there can be a question statement here. Now, the governor has to ensure that the money provided by the central government for any specific purpose, for example, 500 crore are provided by central government as a grant for, say, drinking water facilities. Okay. Now this fund has been received. Now, can state government utilize this fund in other activities? No. And who is going to ensure that? Governor is going to ensure that. Now, so you would be thinking, sir, how governor can stop the state government? Because I told you when we discussed governor chapter that when it comes to grants, appropriation of the funds from consolidated fund of state, that needs to be passed from state legislative assembly, and after getting passed from here, it needs assent of governor, right? And that is why governor has a say there. Related to that purpose only, not in other demand moved in the state legislative assembly. I hope it is clear to you now. Now, a regional council consisting of 35 members. Now, please remember the name of district we are going to talk about now. Okay, should be established for the Sunsang district in the state. There is a specific, the special council consisting 35 members. The governor should make rules for the composition of the council, manner of choosing its members. UPSC will make a statement that these members, 35 members of this council are nominated by governor only. It's not necessary, because manner is decided by governor. Their qualification, terms, salaries, allowances, etc. The procedure and conduct of business of the council, it is also going to be decided by governor. Appointment of officers, staff of the council and their service conditions, this is also going to be decided by governor. So, governor of Nagaland is having considerable power due to these special provisions for a period of 10 years. So, please remember there are two actually options here. One is this provision is going to extend, means establishment of this council for Sunsang district will extend for 10 years, or governor will have power to extend it. For such period, the governor may specify, right? The administration of Sunsang district shall be carried on by the governor. The governor shall in his discretion arrange for equitable distribution of money provided by the central between Sunsang district and the rest of the Nagaland. Okay. Any act of Nagaland legislature shall not apply to Sunsang district unless governor directs. There can be a question here. Means in this case, governor's say is more than the say of state legislature, right? With respect to this district. Clear? Now, make regulations for peace, progress. I think it is clear to you now. I think this is clear. There shall be a minister for Sunsang district. This provision is important. In Council of Ministers of Nagaland, there will be a special minister for this. It can be possible there is a minister and he is having additional charge for Sunsang district affairs. Okay? Or that person need to be selected, I would say. That person is already a member of legislature or need to be a member of legislature within 6 months when that person is appointed as minister, but that person should belong to Sunsang district only. Now, with respect to Assam and Manipur, President is empowered to provide for the creation of Committee of Assam Legislative Assembly. Now, with respect to Assam and Manipur, there are a lot of similarities. Okay, that is why, but just remember, the President is going to empower to actually create a specific committee consisting of members elected from tribal areas of the state and such other members he may specify. He means elected members of state legislative assembly, state legislature. They are going to be part of the special committee. And who are those elected? Elected from tribal areas, right? So it means this provision was made so that rights of these tribals can be ensured, right? Now, Article 371C, President is authorized to provide the creation of Committee of Manipur Legislative Assembly. So there we are talking about Committee of Assam Legislative Assembly here, Committee of Manipur Legislative Assembly. Obviously, members are going to be from the assembly itself, right? Consisting of the members elected from hill areas of that state. The President can also direct that the governor shall have special responsibility to secure proper functioning of that committee. So these are the two provisions. Now, governor should submit annual report to the President regarding the administration of hill areas, and there can be a question from here. Okay, so we are talking about Assam, Manipur. The central government can give direction to the state government to administration of the hill areas. Now, talking about Andhra Pradesh and Telangana, DE means 371D and 371E. They are related to Andhra Pradesh and Telangana. 371D was extended to Telangana itself because you know that bifurcation of state happened. The President is empowered to provide equitable opportunities and facilities for the people belonging to different parts of that state. Please remember, now we are going to talk about education and government jobs. What special rights these two states have. Education and jobs. President may require the state government to organize civil posts for local cadres of different parts of the state so that the local people can have representation in the jobs there. Okay, we are talking about government jobs. May specify part of the state which may be regarded as the local area, and which area is going to be regarded as local area, that can also be specified. He may also specify extent and manner of preference, means how much reservation you are going to give and in what way you are going to give in the matter. And please remember, in all of these points, I am again and again using the word he, and he or she is the position of President. Okay. So I think it is clear to you: education and jobs, reservation, local population. These four keywords you need to remember, that's it. President may provide establishment of an administrative tribunal. Now here you need to remember, there is a dedicated administrative tribunal, and this administrative tribunal is beyond the supervision of High Court. Okay. Only you can say the matter here can only be dealt later by Supreme Court. Okay. Outside the purview of State High Court, no court other than Supreme Court is to exercise any jurisdiction with respect to matters subject to this tribunal. And why this tribunal was made? Because we are talking about new provisions, reservation, local population in the civil positions. So there are chances there will be grievances, dispute with respect to government positions which are going to be dealt in this manner. Such disputes are going to be taken by this specific tribunal. President may abolish the tribunal when he is satisfied that now circumstances such are not existing. Now attempt this question. Under the provisions of Article 371E, we have just talked about 371D, okay? But question is from E. Which of the following is empowered to provide establishment of Central University in State of Andhra Pradesh? Central University in State of Andhra Pradesh. Look at the options. President of India, Parliament of India, Legislative Assembly of Andhra Pradesh, Governor of Andhra Pradesh. Answer is Parliament. Why? Directly it is mentioned here. Empowers Parliament to provide for the establishment of a Central University in Andhra Pradesh. Direct statement kind of questions were asked. Now provisions related to Sikkim. All of you know that Sikkim was later, means when we got independence, when Constitution was enacted, Sikkim was not part of India. Right, they were having monarchy there, right? But later it was included. Which of the following can extend with restrictions modification to Sikkim any law which is in force in the State of Union of India? So which can extend such laws? So we have answer President of India. Why we are saying that? It is as per the special provision. As per 36th Constitutional Amendment Act, full-fledged state status was given to Sikkim in Indian Union. It included Article 371F. So DE were Andhra Pradesh, Telangana, right? After E we are having F with respect to Sikkim. Now Sikkim Legislative Assembly is to consist of not less than 30 members. Now also remember these lines, we are going to talk about them also because UPSC has asked questions on that. Now there is a uniqueness in the Legislative Assembly of Sikkim, because in other states you know that when it comes to MLA, Member of Legislative Assembly, we follow the concept of territorial constituency, right? So you represent this territory and all the members, all the valid voters here, all the members living here, you are their representative, right? And valid voters, they are going to vote. But this is not the case in special cases which are given to Sikkim. For example, with respect to the monasteries which are present in Sikkim, they can have their own representative as MLA in a Sikkim legislature. So in that case, that MLA is not representing a specific area, that MLA is representing a section, right? And how is it possible? It is possible due to this Article 371F. UPSC can ask question from here because it's an exceptional kind of case. That is why please remember it. One seat is allocated to Sikkim in Lok Sabha. Sikkim forms one parliamentary constituency. Now, for the purpose of protecting the rights and interests of the different sections of the Sikkim population, the parliament is empowered to provide for the, what they are providing, number of seats in Sikkim Legislative Assembly which may be filled by candidate belonging to such sections. Delimitation of assembly constituencies which candidates belonging to such section alone may stand for election to the assembly. After reading this, some students actually just understand, oh, they're talking about reservation it seems, right? And this reservation seems like it is beyond the definition of SCs and STs. That is what you get, right? But I have told you, this monastery, section, representation, difference from territorial constituency concept, right? The governor shall have special responsibility for peace, equitable arrangement of ensuring social economic. Now, the discharge of this responsibility, governor shall act as in discretion, subject to the direction issued by president. Discretion part is there, that is why please remember. The president can extend with restriction modification to Sikkim any law which is in force in the state of the Indian Union. President has power with respect to Sikkim. Now coming to Mizoram, the acts of parliament related to Mizoram. So what special, you can say avenues they have. Such question was asked by UPSC in case of Nagaland. Now it can be asked in case of Mizoram. So if you have just, we have gone through Nagaland, right? So just see the similarities, right? And it will be easy for you to relate. Religious and social practice of Mizos, Mizo customary law and procedure, administration of civil and criminal justice involving Mizo customary law, ownership and transfer of land. Don't you think all these special provisions were given to Nagaland also, right? And this state legislative assembly consists of not less than 40 members. Now talking about Arunachal Pradesh and Goa, just attempt this question. Governor of Arunachal Pradesh shall have special responsibility of law and order. Arunachal Pradesh legislative assembly is to consist of at least 40 members. So actually this is wrong. We have 30 there, that is why only one is correct. So the governor shall have special responsibility for law and order, right? In the discharge of responsibility, the governor, after consulting with Council of Ministers, individual judgment, decision, this special responsibility governor shall seize when president so direct. So we also discussed this, right? This special responsibility can be taken away by the president. The Arunachal Pradesh, I told you, not less than 30 members, but in this question it was saying not less than 40 members. Goa provides that Goa Legislative Assembly shall not consist of not less than 30 members. Can you tell me how many members are there in Goa Legislative Assembly? That was in news few times back due to this hung assembly which actually went there. 40. Now, but here it was saying not less than. So not less than is 30. Okay. Provision for Karnataka. So in Karnataka, you have this Karnataka here. But actually this Hyderabad, initially this Hyderabad was a Hyderabad state, before it became part of Indian Union. So some part here in Karnataka, we say this is Hyderabad Karnataka region. And to remove the disparities in economic progress, these provisions were added. Established a special development board for Hyderabad Karnataka region, making a provision that report on working of the board every year before the state legislative assembly. Please remember, when you are using the word Hyderabad, we are not talking about Hyderabad as a capital of Telangana. Okay, we are talking about that Hyderabad region, which we say is a region of Karnataka. Okay, because Hyderabad state was there. It was quite bigger, than the city which we are having now. The equitable allocation of funds, development, reservation seats in education institutions, vocational training, reservation in state government posts. So it means we are talking about education and jobs. We are talking about reservation, and we are talking about local. So these 4 keywords you need to remember. That's it. 371J, which provides for special provision for this Karnataka Hyderabad. 98th Constitutional Amendment 2012 was added. Actually, before that, I'm talking about 2010. So Karnataka Legislative Council and as well as Assembly actually passed resolutions in this regard, that we need some special provisions here. Establishment of an institutional mechanism for equitable allocation of funds, development needs, enhance human resource, promote employment, education, reservation. 4 keywords that I'm telling you that you need to remember. That's it. 2010, as I told you, there is the demand. Resolution sought to accelerate development of most backward regions, promote inclusive growth, intra-regional and inter-district disparities that they need to be removed, and that is why this was created. So these are the provisions. Part 6 of the Indian Constitution, India is not applicable to. Part 6, what is Part 6? States. Part 5 is Union. So is not applicable to which of the following state? Answer is applicable in all states in India. So I hope now this part is clear to you. See you in the next video. Till then, keep learning, keep growing.